Hello, and welcome to this evening's journey through time. Tonight, we'll unfold another page of history and listen closely to the voices it left behind. Maybe you're lying in bed, phone screen dimmed, or maybe you've simply chosen to let the past keep you company for a while. Where are you joining me from tonight? Leave a comment if you'd like. I always enjoy hearing about your corner of the world and what time it is for you. If you find comfort in slow, thoughtful stories about the people who came before us, I'd be honored if you subscribed. Now, before we dive into this rabbit hole of medieval madness, let me tell you why this matters. The Viking legal system wasn't just some primitive barbarism. It was actually one of the most sophisticated legal frameworks of its time, influencing laws across Europe and even reaching into modern legal systems today. These weren't just bloodthirsty raiders pillaging villages. They were creating democratic assemblies, establishing complex property rights, and developing legal procedures that would make any modern lawyer's head spin. But here's what makes this even more fascinating. Everything you think you know about Viking justice is probably wrong. Hollywood has painted these people as savage brutes who solved every problem with an axe to the face. The reality is so much weirder and more complex than anything you've seen in movies or TV shows. So buckle up, because we're about to explore a legal system where trial by ordeal was considered perfectly reasonable, where women had more legal rights than they would have for centuries afterward, and where the concept of outlawry meant something far more terrifying than just being kicked out of town. Have you ever wondered what it would be like to live in a world where your word was literally your bond? Where lying under oath could result in immediate divine punishment, and where the entire community would gather to witness legal proceedings that were part courtroom drama, part religious ceremony, and part public entertainment. The Viking legal system operated on principles so foreign to our modern understanding that it might as well have been designed by aliens. But here's the thing that's going to blow your mind. In many ways, it was more fair, more democratic, and more progressive than legal systems that came hundreds of years later. Let me paint you a picture of what we're dealing with here. Imagine a society where there were no professional judges, no lawyers, no police force, and no prisons. Yet somehow, they managed to create a legal framework that maintained order across vast territories, resolved complex disputes, and established precedents that lasted for centuries. The foundation of Viking justice rested on something called the Thing, which sounds like a horror movie monster, but was actually their version of a court and parliament rolled into one. These weren't just legal proceedings. They were massive social events where entire communities would gather to settle disputes, make laws, and decide the fate of accused criminals. But here's where it gets really weird. The Vikings believed that the gods were actively involved in their legal system. They weren't just asking for divine guidance, they literally expected supernatural intervention in their trials. This wasn't superstition to them, this was science. Think about that for a moment. You're living in a world where the outcome of a legal case might depend on whether you can walk across red-hot iron without getting burned, or whether you sink or float when thrown into a lake. To us, this sounds insane. To them, it was the most reliable way to determine guilt or innocence, because they believed the gods would never let an innocent person suffer. Now, I know what you're thinking. This has to be exaggerated folklore, right? Surely people weren't actually making life and death decisions based on whether someone could hold a piece of burning metal without screaming. But the archaeological evidence and historical records are crystal clear. This stuff actually happened, and it happened regularly. The Vikings had developed an entire taxonomy of ordeals, each designed for different types of crimes and circumstances. There was trial by hot iron, trial by boiling water, trial by cold water, and even trial by blessed bread that would supposedly choke a guilty person. They had turned divine judgment into a systematic legal procedure with specific rules, protocols, and ceremonial requirements. But before you dismiss this as primitive nonsense, consider this. Modern lie detector tests are based on the exact same principle. The idea that guilt will manifest itself through physical symptoms isn't actually that different from measuring heart rate, blood pressure, and skin conductance to determine if someone is telling the truth. The Vikings just cut out the middleman and went straight to divine intervention. And here's something that's going to mess with your head even more. In many cases, these ordeals probably worked. Not because the gods were actually intervening, but because of the psychological pressure involved. If you knew you were guilty and believed that God would expose your lies through supernatural means, you might very well confess before the ordeal even began. The system was as much about psychological warfare as it was about divine judgment. But ordeals were just one part of a much larger and more complex legal framework. The Vikings had developed sophisticated concepts of evidence, witness testimony, and legal representation that were remarkably advanced for their time. They understood the difference between different types of crimes, had specific procedures for different types of cases, and had created a system of appeals that could escalate disputes to higher authorities. What's really fascinating is how democratic their legal system was. Unlike medieval Europe, where justice was often dispensed by kings and nobles according to their whims, Viking legal proceedings were fundamentally communal affairs. Every free man had the right to participate in the thing, to speak on behalf of the accused, and to vote on the outcome of cases. Women, too, had legal rights that were unheard of in most other medieval societies. They could own property, initiate divorce proceedings, and even serve as legal representatives in certain circumstances. This wasn't some progressive social movement. This was just how their society functioned. The concept of outlawry in Viking society deserves special attention because it was perhaps their most feared punishment, and it was nothing like what you might imagine. Being declared an outlaw didn't just mean you were kicked out of town and told not to come back. It meant you were legally dead while still breathing. An outlaw had no legal protection whatsoever. Anyone could kill you without consequence. You couldn't own property, enter into contracts, or even receive help from family members without putting them at risk. You were essentially a ghost haunting the edges of society, neither fully alive nor properly dead. But here's the brilliant part of this system. It was reversible. Unlike execution, outlawry could be lifted if circumstances changed or if the outlaw made proper restitution. It was a punishment that could be as permanent or temporary as the situation required. The Vikings also developed one of the most sophisticated systems of compensation and restitution in the medieval world. Rather than focusing primarily on punishment, their legal system was designed to restore balance and make victims whole. If you killed someone, you didn't automatically face execution. Instead, you might be required to pay weregild, a compensation payment to the victim's family. These weren't arbitrary amounts either. The Vikings had developed detailed schedules of compensation that took into account the social status of the victim, the circumstances of the crime, and the ability of the perpetrator to pay. They had essentially created a medieval version of personal injury law, complete with standardized damage awards and payment plans. This system of compensation extended to all kinds of crimes and disputes. Property damage, personal injury, theft, even insults and slander had specific compensation requirements. The Vikings understood that crime created imbalances in society, and their legal system was designed to restore equilibrium rather than simply punish wrongdoers. But don't think this made them soft on crime. The Vikings could be absolutely ruthless when the situation called for it. Certain crimes, particularly those that threatened the social order or violated sacred oaths, could result in punishments that were genuinely horrifying. Blood eagles, ritual drowning, and other forms of execution that were designed to send a message to anyone who might consider similar crimes. The key to understanding Viking justice is recognizing that it operated on multiple levels simultaneously. There was the practical level of resolving disputes and maintaining order. There was the social level of reinforcing community values and hierarchies. And there was the spiritual level of maintaining proper relationships with the gods and the natural order. These weren't separate systems. They were all part of one integrated approach to justice that touched every aspect of Viking society. The legal proceedings weren't just about determining guilt or innocence. They were about reaffirming the cosmic order and ensuring that the community remained in harmony with divine will. What makes this even more remarkable is how consistent these legal principles were across the entire Viking world. From Iceland to Russia, from Greenland to Constantinople, Viking communities maintained remarkably similar legal traditions and procedures. This wasn't because they had some central authority dictating legal standards. It was because their legal system was so deeply embedded in their culture and worldview that it traveled with them wherever they went. The sophistication of Viking legal thinking becomes even more apparent when you look at how they handled complex cases involving multiple jurisdictions or competing legal claims. They had developed procedures for determining which legal authority had jurisdiction over a case, how to handle conflicts between different legal traditions, and how to enforce judgments across territorial boundaries. This legal framework wasn't static either. Viking law evolved and adapted as their society changed and as they encountered new situations and challenges. The legal codes that survive from different periods show clear evidence of legal innovation and refinement over time. The sophistication becomes even more mind-blowing when you realize they were doing all of this without any written legal codes for most of their history. That's right. This entire complex system of justice was maintained through oral tradition, passed down from generation to generation through memory and practice. Every legal precedent, every procedural requirement, every compensation schedule was stored in the collective memory of the community. Think about the implications of that for a moment. In our modern world, we have thousands of pages of written laws, countless legal textbooks, and armies of lawyers who specialize in tiny fragments of the legal system. The Vikings managed to maintain a legal framework that was arguably more comprehensive and certainly more consistent than many modern systems. And they did it all through storytelling and communal knowledge. This oral tradition wasn't a weakness. It was actually a strength. Because the law lived in the minds of the people rather than in dusty books, it remained flexible and responsive to changing circumstances. Legal precedents could evolve naturally as society changed, without requiring formal legislative processes or constitutional amendments. But here's where things get really interesting. The Vikings understood something about human psychology that modern legal systems often miss. They knew that justice isn't just about applying rules. It's about satisfying the emotional and social needs of everyone involved in a dispute. When someone was wronged in Viking society, the legal system didn't just focus on punishing the wrongdoer or compensating the victim. It created elaborate rituals and ceremonies that allowed the entire community to participate in the resolution of the conflict. These weren't just legal proceedings. They were therapeutic events that helped heal the social fabric torn by crime or dispute. Consider the process of oath swearing, which was central to Viking legal proceedings. This wasn't just a matter of promising to tell the truth. It was a sacred ritual that involved invoking the gods, handling sacred objects, and making declarations in front of the entire community. The act of swearing an oath was believed to create a direct connection between the oath-taker and divine forces. Breaking an oath wasn't just perjury, it was a cosmic crime that would bring divine retribution, not just on the oath-breaker, but potentially on their entire family and community. This created incredibly powerful incentives for honesty that went far beyond any earthly punishment. The Vikings had also developed sophisticated methods for evaluating the credibility of witnesses and the reliability of evidence. They understood that not all testimony was equally valuable, and they had created systems for weighing different types of evidence based on the social status of witnesses, their relationship to the parties involved, and their reputation for truthfulness. This is where the concept of honor becomes crucial to understanding Viking justice. In their society, reputation wasn't just important for social status. It was literally a matter of legal standing. A person with a good reputation could provide testimony that would be accepted without question, while someone with a damaged reputation might find their word worthless in legal proceedings. This created a powerful system of social control that extended far beyond formal legal proceedings. Everyone knew that their actions and behavior would affect not just their immediate circumstances, but their ability to participate effectively in the legal system throughout their entire lives. But the Vikings took this concept even further with something called compurgation, which is probably one of the weirdest legal concepts you've never heard of. If you were accused of a crime, you could sometimes clear yourself not by proving your innocence, but by finding enough people willing to swear that you were the kind of person who wouldn't commit such a crime. These weren't character witnesses in the modern sense. These were oath helpers who were literally staking their own reputations and potentially their lives on your innocence. If it later turned out that you were guilty, everyone who had sworn for you would face serious consequences. This created a system where your social network became your legal defense team. The genius of this system was that it made it almost impossible for habitual criminals to escape justice. If you had a pattern of bad behavior, you simply wouldn't be able to find enough people willing to risk their reputations by swearing for you. Your past actions would literally determine your ability to defend yourself against future accusations. The Vikings also understood something that modern legal systems struggle with: the difference between different types of harm and the appropriate responses to each. They had developed nuanced categories of crimes that took into account not just the physical damage done, but the social and spiritual implications of different actions. For example, they distinguished between accidental killings, killings in the heat of passion, premeditated murders, and killings that occurred during the commission of other crimes. Each category had different legal procedures, different compensation requirements, and different potential punishments. They even had special categories for crimes that we would consider relatively minor, but that they viewed as particularly serious because of their social implications. Theft from a guest, for instance, was considered far more serious than ordinary theft because it violated the sacred obligations of hospitality. The concept of sanctuary in Viking law was also remarkably sophisticated. Certain places, times, and circumstances provided legal protection that couldn't be violated without incurring severe consequences. These weren't just religious sanctuaries. They included things like protective boundaries around legal assemblies, safe conduct during certain festivals, and immunity for people traveling to or from legal proceedings. This system of sanctuary created safe spaces where even bitter enemies could interact without fear of violence, allowing the legal system to function even in the midst of ongoing feuds and conflicts. Speaking of feuds, the Viking legal system had developed elaborate procedures for managing and resolving ongoing conflicts between families and communities. They understood that some disputes couldn't be resolved with a single legal proceeding, and they had created mechanisms for managing long-term conflicts while preventing them from destroying society. The concept of the peace weaver is particularly fascinating. Sometimes ongoing feuds would be resolved through arranged marriages that would literally weave the warring families together. The woman who married into the opposing family wasn't just a bride. She was a living peace treaty whose children would embody the reconciliation between former enemies. But perhaps the most remarkable aspect of Viking justice was how it handled cases where the normal legal procedures couldn't provide a clear resolution. When evidence was inconclusive, when witnesses contradicted each other, or when the stakes were so high that ordinary legal procedures seemed inadequate, they would resort to what they called God's judgment. This is where we get back to those trials by ordeal that seem so bizarre to modern eyes. But these weren't random acts of superstition. They were carefully regulated legal procedures with specific rules about when they could be used, how they should be conducted, and what the results meant. The ordeal by hot iron, for instance, required the accused to carry a piece of red-hot metal for a specific distance while reciting specific prayers. The burn would then be bandaged and examined after 3 days. If it was healing cleanly, the person was innocent. If it showed signs of infection or poor healing, they were guilty. To us, this seems like pure chance, but the Vikings believed they were creating conditions where divine intervention could manifest clearly. They weren't leaving things to random chance. They were creating opportunities for supernatural justice to operate. The ordeal by cold water involved binding the accused and lowering them into a body of water that had been blessed by a priest. If they floated, they were guilty because the pure water was rejecting them. If they sank, they were innocent, though hopefully someone would fish them out before they drowned. These ordeals weren't used casually or frequently. They were reserved for the most serious cases, and there were elaborate procedures that had to be followed before an ordeal could be ordered. The accused had to consent to the ordeal, witnesses had to be present, and specific religious ceremonies had to be performed. What's really remarkable is that we have records showing that people sometimes requested trial by ordeal when they felt that ordinary legal procedures wouldn't vindicate them. They preferred to put their fate in the hands of the gods, rather than risk an unfavourable verdict from human judges. The psychological impact of these ordeals extended far beyond the immediate participants. Everyone in the community would know that divine justice was available as a last resort, which created powerful incentives for honest behaviour and fair dealing in all aspects of life. But the Vikings didn't rely solely on supernatural intervention. They had also developed sophisticated investigative procedures for gathering evidence and determining facts. They understood the importance of preserving crime scenes, interviewing witnesses separately to check for inconsistencies, and following physical evidence to logical conclusions. They had even developed early forms of forensic analysis. They could determine the cause of death by examining wounds, trace stolen property through distinctive markings, and identify individuals based on physical evidence left at crime scenes. The role of women in Viking legal proceedings deserves special attention because it challenges so many assumptions about medieval society. Women could not only own property and initiate legal proceedings, they could also serve as witnesses, provide oath-helping support, and even represent others in certain types of cases. A woman's legal testimony was generally considered as reliable as a man's, and in some circumstances, it was considered more reliable. Women were thought to be particularly trustworthy in cases involving domestic disputes, property inheritance, and matters related to marriage and family relationships. Viking divorce law was particularly progressive for its time. Either spouse could initiate divorce proceedings, and there were specific grounds for divorce that protected both parties from abuse or abandonment. Property division was handled according to detailed rules that ensured both parties received fair treatment. The legal rights of children were also remarkably well developed. The Vikings understood that children needed special protection under the law, and they had created guardianship systems that ensured orphaned or abandoned children would be cared for, and that their property rights would be protected until they reached adulthood. Inheritance law was incredibly detailed and sophisticated, taking into account not just direct descendants, but extended family relationships, adoption, and even the rights of illegitimate children. They had developed procedures for handling contested inheritances that could involve multiple generations and complex family relationships. The Vikings also understood that legal systems needed to be accessible to everyone, not just the wealthy and powerful. They had developed procedures that allowed poor people to participate fully in legal proceedings, including systems for providing legal support and representation to those who couldn't afford it. The concept of legal aid in Viking society was far more advanced than anything that existed in medieval Europe for centuries afterward. If you couldn't afford to pay for oath helpers or legal representation, the community would often step in to ensure you received a fair hearing. This wasn't charity, It was a recognition that injustice anywhere in the community threatened the stability of the entire social order. But here's where Viking justice gets absolutely mind-bending. They had developed what we might call early forms of plea bargaining and alternative dispute resolution. Before cases ever reached the formal thing assembly, there were elaborate systems of mediation and negotiation designed to resolve conflicts without the need for public trials. These weren't informal conversations between neighbors. They were structured legal procedures with specific rules about who could serve as mediators, what kinds of agreements could be reached, and how those agreements would be enforced. The Vikings understood that not every dispute needed to become a public spectacle, and they had created sophisticated mechanisms for private resolution. The role of professional arbitrators in Viking society is something that would make modern lawyers weep with envy. These weren't just wise old men dispensing folksy advice. They were legal specialists who had memorized vast amounts of legal precedent and procedure, who understood the complex relationships between different legal codes, and who could navigate the most complicated disputes with surgical precision. These arbitrators were so respected that their decisions were often accepted even by parties who had no legal obligation to abide by them. Their reputation for fairness and legal knowledge gave them authority that transcended formal legal structures. They were walking, talking legal libraries in a society that had no written law books. What's absolutely fascinating is how the Vikings handled cases involving foreigners or people from different legal traditions. They didn't just impose their own laws on everyone. They had developed sophisticated systems for determining which legal framework should apply in cases involving multiple jurisdictions or competing legal claims. Sometimes they would apply the law of the accused person's homeland. Sometimes they would use the law of the place where the crime occurred. And sometimes they would create hybrid procedures that combined elements from different legal traditions. They were doing international law centuries before anyone had even conceived of the concept. The Vikings had also figured out something that modern legal systems still struggle with: how to handle crimes that cross community boundaries. If someone from one village committed a crime in another village, whose law applied? Who had jurisdiction? How would judgments be enforced across territorial lines? They solved this through a complex network of legal agreements between communities that established mutual recognition of legal procedures and enforcement mechanisms. These weren't formal treaties negotiated by kings and diplomats. They were grassroots agreements between communities that created a kind of legal common market across the Viking world. The enforcement of judgments in Viking society deserves special attention because they had no police force, no standing army, and no centralized authority to compel compliance with legal decisions. Yet somehow, their legal system maintained remarkable effectiveness across vast distances and diverse communities. The secret was something called collective responsibility. When a legal judgment was rendered, it wasn't just the responsibility of the parties involved to comply. The entire community became responsible for ensuring that the judgment was carried out. This created powerful social pressure that made non-compliance almost impossible. If someone refused to pay compensation that had been awarded by a legal proceeding, they wouldn't just face consequences from the victim. They would face ostracism from the entire community. Their neighbors would refuse to trade with them. Their family would be shamed, and their social standing would be destroyed. But the Vikings took this concept of collective responsibility even further. In some cases, if an individual refused to comply with a legal judgment, their entire family, or even their entire community, could face consequences. This created incredibly powerful incentives for communities to police themselves and ensure that their members behaved responsibly. The concept of legal pollution in Viking society is something that sounds almost mystical to modern ears, but it was a very real and practical aspect of their legal system. Certain crimes were believed to create a kind of spiritual contamination that could spread throughout the community if not properly addressed. Murder, oath-breaking, and violations of hospitality were considered particularly polluting crimes that required elaborate cleansing rituals in addition to normal legal penalties. The community couldn't just punish the wrongdoer and move on. They had to actively purify themselves to prevent the contamination from spreading. These purification rituals weren't just religious ceremonies. They were legal procedures with specific requirements and consequences. Failure to properly cleanse the community after a polluting crime could result in divine retribution that would affect everyone, not just the original wrongdoer. The Vikings had developed an incredibly sophisticated understanding of what we might call restorative justice. Their legal system wasn't primarily focused on punishment. It was focused on healing the damage that crime and conflict created in the social fabric. When someone committed a crime, the legal system didn't just ask how the wrongdoer should be punished. It asked how the victim could be made whole, how the community could be healed, and how future crimes could be prevented. This holistic approach to justice created legal procedures that addressed the emotional, social, and spiritual dimensions of conflict, not just the legal technicalities. The role of storytelling in Viking legal proceedings is something that completely changes how we understand their approach to justice. Legal cases weren't just about presenting facts and applying rules. They were about constructing narratives that would help the community understand the deeper meaning of the conflict. Skilled legal advocates would weave elaborate stories that place the immediate dispute in the context of family histories, community relationships, and cosmic principles. These weren't just legal arguments. They were works of art that could move audiences to tears, rage, or profound understanding. The ability to tell a compelling legal story was considered one of the highest forms of intellectual achievement in Viking society. The greatest legal advocates were remembered and celebrated like we remember great authors or filmmakers today. Their legendary legal performances became part of the oral tradition that was passed down through generations. What's remarkable is how these narrative techniques actually improved the quality of legal decision-making. By requiring advocates to place their cases in broader contexts, the legal system forced everyone to consider the long-term implications of their decisions and the complex web of relationships that connected all members of the community. The Vikings had also developed sophisticated methods for handling cases where the normal adversarial process might not produce just results. They understood that some disputes were so complex or emotionally charged that traditional legal procedures might actually make things worse rather than better. In these cases, they would sometimes use what we might call therapeutic jurisprudence. Instead of focusing on determining guilt and innocence, the legal proceeding would focus on helping the parties understand each other's perspectives and find ways to move forward constructively. These therapeutic legal procedures weren't soft or touchy-feely. They were rigorous processes that required participants to confront difficult truths about themselves and their relationships. But they were designed to produce healing rather than just judgment. The concept of legal time in Viking society is something that challenges our modern assumptions about how justice should work. We expect legal proceedings to move quickly and efficiently toward definitive conclusions. The Vikings understood that some conflicts needed time to ripen before they could be properly resolved. They had developed procedures that could stretch legal proceedings across months or even years, allowing emotions to cool, relationships to evolve, and new information to emerge. This wasn't inefficiency. It was a recognition that premature legal resolution could sometimes cause more problems than it solved. During these extended legal processes, the parties weren't left in limbo. There were specific procedures for managing ongoing relationships, preventing escalation of conflicts, and ensuring that everyone's interests were protected while the case slowly moved toward resolution. The Vikings had even figured out how to handle legal cases that involved supernatural elements or claims that couldn't be verified through normal means. They didn't dismiss these cases as nonsense. They had developed specific procedures for evaluating supernatural claims and determining appropriate responses. If someone claimed to have been cursed, bewitched, or harmed through magical means, the legal system would take these claims seriously and investigate them using methods appropriate to supernatural crimes. They had specialists who could evaluate magical evidence, witness testimony about supernatural events, and determine appropriate remedies for supernatural harm. This wasn't because the Vikings were more superstitious than other medieval peoples. It was because they understood that people's beliefs about supernatural forces were real social facts that had real consequences for community relationships and individual behavior. The integration of practical and spiritual elements in Viking legal proceedings created a system that operated on multiple levels simultaneously. Every legal case was simultaneously a practical dispute resolution, a religious ceremony, a social event, and a cosmic drama involving the fundamental forces that govern the universe. This multi-dimensional approach to justice created legal proceedings that were incredibly rich and meaningful for all participants. People didn't just get legal resolution, they got spiritual purification, social healing, and cosmic realignment all in one comprehensive process. The sophistication of Viking contract law is something that would impress modern business lawyers. They had developed detailed procedures for creating, modifying, and enforcing agreements that covered everything from simple trade transactions to complex business partnerships and long-term commercial relationships. These contracts weren't just informal handshake deals. They were elaborate legal instruments with specific terms, conditions, and enforcement mechanisms. The Vikings understood that complex economic relationships required sophisticated legal frameworks to function effectively. They had developed concepts of warranty, liability, risk allocation, and dispute resolution that were remarkably similar to modern commercial law. They understood the difference between different types of contractual obligations and had created appropriate legal remedies for different types of contractual failures. The role of credit and debt in Viking society was also highly sophisticated. They had developed complex systems for extending credit, managing debt obligations, and handling situations where debtors couldn't meet their obligations. These weren't just economic arrangements, they were social relationships that were governed by detailed legal frameworks. Viking bankruptcy law was particularly advanced. They understood that sometimes people couldn't pay their debts through no fault of their own, and they had developed procedures for reorganizing debt obligations, protecting essential assets, and allowing debtors to make fresh starts without completely destroying their social standing. The legal treatment of partnerships and joint ventures in Viking society reveals a deep understanding of the complexities of shared economic activity. They had developed detailed rules for profit sharing, decision-making, liability allocation, and partnership dissolution that would be familiar to any modern business lawyer. What's particularly impressive is how they handled partnerships that involved people from different communities or legal traditions. They had developed sophisticated choice of law rules and dispute resolution mechanisms that could handle the most complex international business relationships. The Vikings had also figured out how to handle intellectual property concepts centuries before anyone else even recognized that such things existed. They had developed legal protections for trade secrets, craft techniques, and other forms of valuable knowledge that gave individuals and communities competitive advantages. These weren't formal patent systems, but they were sophisticated legal frameworks that balanced the interests of innovators with the needs of the broader community. They understood that innovation needed to be rewarded, but they also recognized that excessive secrecy could harm social and economic development. The legal status of slaves in Viking society was complex and reveals both the harsh realities of medieval life and the sophisticated legal thinking that characterized their approach to justice. Slaves weren't just property. They had specific legal rights and protections that limited how they could be treated by their owners. The Vikings had developed detailed rules about the treatment of slaves, the conditions under which slaves could be freed, and the legal status of freed slaves. They understood that the treatment of slaves reflected on the moral character of the entire community, and they had created legal frameworks designed to prevent the most extreme forms of abuse. The process of manumission, or slave liberation, was highly regulated and involved elaborate legal ceremonies that formally changed the legal status of the freed person. These weren't just private agreements between masters and slaves. They were community events that required witness testimony and formal legal recognition. Viking marriage law was incredibly sophisticated and reveals a deep understanding of the complex social, economic, and emotional dimensions of family relationships. Marriage wasn't just a private arrangement between two individuals. It was a legal institution that created networks of obligation and support that extended throughout the community. The legal requirements for valid marriages were detailed and specific. There were rules about consent, age, family approval, and public recognition that ensured marriages were legitimate and socially accepted. But there were also provisions for different types of marriages that recognized the diverse ways that people might choose to structure their relationships. The concept of concubinage in Viking society was legally recognized and regulated. These weren't just informal sexual relationships. They were legal arrangements with specific rights and obligations for all parties involved. Children from these relationships had legal rights and inheritance claims that were protected by detailed legal frameworks. Divorce procedures were remarkably equitable and provided protections for both spouses. Either party could initiate divorce proceedings under specific circumstances, and there were detailed rules for property division, child custody, and ongoing support obligations that ensured both parties were treated fairly. The legal treatment of domestic violence in Viking society was surprisingly progressive. They recognized that violence within families was a serious crime that required legal intervention, and they had developed specific procedures for protecting victims and punishing abusers. These weren't just formal legal rules that existed on paper. They were actively enforced community standards that were taken seriously by everyone involved in the legal system. The Vikings understood that family violence threatened the stability of the entire social order, and they responded accordingly. The role of children in Viking legal proceedings reveals a sophisticated understanding of child development and the special needs of young people. Children weren't just miniature adults, they were recognized as having different capabilities and needs that required special legal protections. The Vikings had developed detailed rules about the age at which children could participate in various legal activities, the circumstances under which children could be held responsible for their actions, and the obligations that adults had to protect and support children in their care. The concept of legal guardianship was highly developed and included not just care for orphan children, but also protection for children whose parents were unable to care for them properly. These guardianship arrangements were formal legal relationships with specific rights and obligations that were enforced by the community. The treatment of mental illness and disability in Viking legal proceedings shows a remarkable degree of compassion and understanding for conditions that were poorly understood in medieval times. They recognized that some people had diminished capacity for legal responsibility, and they had developed appropriate legal frameworks for protecting these vulnerable individuals. Rather than simply excluding people with mental illness or disabilities from legal proceedings, the Vikings had created modified procedures that allowed these individuals to participate in the legal system while providing appropriate protections and support. The concept of legal capacity was nuanced and took into account the specific abilities and limitations of each individual, rather than applying blanket rules that might exclude people unnecessarily from legal participation. The legal framework surrounding property rights in Viking society was so advanced it would make modern real estate lawyers jealous. These weren't just simple concepts of, this is mine, that is yours. The Vikings had developed intricate systems for shared ownership, seasonal use rights, and what we might call timeshare arrangements for valuable resources. Consider how they handled something as basic as land ownership. In most medieval societies, land belonged to kings or lords who granted use rights to peasants. But Viking property law recognized multiple layers of ownership rights that could exist simultaneously on the same piece of land. One person might own the right to graze cattle, another might own timber rights, and a third might own mineral rights, all on the same plot of ground. This wasn't chaos. It was sophisticated legal engineering that maximized the productive use of limited resources while respecting the complex web of relationships that bound communities together. They had developed detailed procedures for transferring these various rights, resolving conflicts between different types of owners, and ensuring that everyone's interests were protected. The concept of adverse possession in Viking law is particularly fascinating. If someone openly used a piece of land for a specific period without objection from the owner, they could actually acquire legal title to that land. But this wasn't just squatters' rights. It was a carefully regulated legal procedure with specific requirements about notice, duration, and the type of use that could establish ownership. This system prevented valuable land from being wasted while still protecting the rights of legitimate owners. It created powerful incentives for landowners to actively manage their property and for communities to make productive use of available resources. Viking water rights law was incredibly sophisticated, which makes sense when you consider how important rivers, lakes, and coastal areas were to their economy and transportation systems. They had developed detailed rules about fishing rights, navigation rights, and the use of water for various industrial purposes. These weren't just local customs that varied from place to place. There were consistent legal principles that governed water rights across the entire Viking world, creating a kind of maritime common law that facilitated trade and travel across vast distances. The legal treatment of intellectual property in Viking society reveals a deep understanding of the value of knowledge and innovation. While they didn't have formal patent systems, they had developed sophisticated ways of protecting and rewarding people who developed new techniques, discovered new trade routes, or created valuable innovations. Craft guilds played a crucial role in this system, serving as both trade organizations and legal entities that could protect the interests of their members. These guilds had their own internal legal systems that could resolve disputes, establish standards, and protect trade secrets. The relationship between guild law and general legal principles was complex and sometimes conflicting. The Vikings had developed procedures for resolving disputes between guild rules and community standards, creating a kind of federal system where different legal authorities had jurisdiction over different aspects of the same activity. But here's where Viking justice gets really mind-bending. They had figured out how to handle crimes that hadn't been committed yet. That's right. They had developed legal procedures for dealing with planned crimes, attempted crimes, and what we might call criminal conspiracies. If someone was discovered planning a serious crime, they could face legal consequences even if they hadn't actually carried out their plan. But this wasn't thought crime persecution. It was a sophisticated legal framework that distinguished between different types of criminal intent and different levels of preparation for criminal activity. The evidence requirements for these anticipatory crimes were incredibly strict. You couldn't just accuse someone of planning a crime based on rumors or suspicion. There had to be concrete evidence of specific preparations, clear testimony from reliable witnesses, and proof that the planned crime posed a genuine threat to the community. The Vikings had also developed what we might call early forms of criminal profiling. They understood that certain patterns of behavior could indicate criminal tendencies, and they had created legal mechanisms for monitoring and managing people who showed these warning signs. This wasn't arbitrary persecution. It was community-based risk management that was designed to prevent crimes before they occurred, while still respecting individual rights and freedoms. People who were identified as potential risks weren't automatically punished, but they might be required to provide surety bonds or find community members willing to vouch for their behavior. The concept of legal sanctuary in Viking society extended far beyond simple physical protection. They had developed sophisticated rules about temporal sanctuary, where certain times of the year provided legal immunity for specific activities or classes of people. During major festivals and religious celebrations, for example, Many types of legal proceedings were suspended, and certain crimes were automatically forgiven. This wasn't just religious observance, it was social engineering designed to provide periodic opportunities for reconciliation and fresh starts. The Vikings understood that rigid enforcement of legal rules could sometimes create more problems than it solved, and they had built flexibility into their system that allowed for periodic reset moments when grudges could be set aside and relationships could be repaired. But perhaps the most remarkable aspect of Viking legal thinking was their understanding of what we might call systemic justice. They didn't just focus on individual crimes and individual punishments. They thought about how legal decisions would affect the overall health and stability of their communities. Every legal proceeding was evaluated not just on its immediate merits, but on its likely long-term consequences for community relationships, social stability, and the maintenance of legal authority. This systemic thinking created legal decisions that were designed to strengthen the overall framework of justice rather than just resolve individual disputes. The role of precedent in Viking law is something that would be familiar to any modern lawyer, but they approached it in a completely different way. Rather than creating rigid rules that had to be followed in all similar cases, they treated precedents as wisdom that could inform future decisions while still allowing for flexibility and adaptation. Legal precedents were embedded in the storytelling tradition that was central to Viking culture. Famous legal cases became part of the oral tradition, passed down through generations as both entertainment and education. These stories didn't just preserve the facts of specific cases, they transmitted the underlying legal principles and the reasoning that led to particular decisions. This narrative approach to legal precedent meant that the law remained alive and dynamic rather than becoming a dead collection of rigid rules. Each generation could reinterpret the old stories in light of new circumstances, while still maintaining continuity with established legal principles. The Vikings had also developed sophisticated methods for handling legal cases that involved conflicting precedents or situations where established legal principles seemed to produce unjust results. They had procedures for distinguishing cases, creating exceptions to general rules, and adapting legal principles to new circumstances. These weren't arbitrary judicial decisions. They were careful legal reasoning processes that involved extensive community discussion and consultation with legal experts. The goal was always to maintain the overall coherence of the legal system while ensuring that individual cases were resolved fairly. The concept of legal standing in Viking society was remarkably inclusive compared to most medieval legal systems. Almost anyone could bring a legal case or participate in legal proceedings, regardless of their social status or economic position. But this inclusiveness came with corresponding responsibilities. If you brought a legal case that was determined to be frivolous or malicious, you could face serious consequences including fines, public humiliation, and damage to your legal standing for future cases. This created powerful incentives for people to use the legal system responsibly, while still ensuring that legitimate grievances could be addressed. The Vikings had developed detailed procedures for evaluating the legitimacy of legal claims and weeding out cases that were designed to harass opponents or waste community resources. These weren't just administrative filters. They were substantive legal procedures that required careful evaluation of evidence and legal reasoning. The role of legal advocacy in Viking society was both more democratic and more demanding than modern legal representation. Anyone could serve as an advocate for someone else, but advocates faced personal consequences if their clients were found to have lied or misrepresented facts. This created a system where legal advocacy was based on genuine belief in the client's case rather than just technical legal skills. Advocates had to be convinced of their client's honesty and the justice of their cause before they could effectively represent them. The relationship between advocates and clients was also more personal and long-term than modern attorney-client relationships. Advocates weren't just providing professional services. They were taking on personal responsibility for their clients' conduct and reputation. The Vikings had developed sophisticated rules about conflicts of interest and the obligations that advocates owed to their clients, the community, and the legal system itself. These rules were designed to ensure that advocacy served the interests of justice rather than just the narrow interests of individual clients. The concept of legal education in Viking society was fundamentally different from modern law schools, but it was incredibly effective at producing people who understood both the technical aspects of law and its deeper social and spiritual significance. Legal knowledge was transmitted through apprenticeship relationships, where young people would attach themselves to experienced legal practitioners and learn through observation and participation. This wasn't just academic study. It was practical training that involved actual participation in legal proceedings. The most advanced legal education took place at the major thing assemblies, where the most complex and important cases were heard. Young legal apprentices would travel from across the Viking world to observe these proceedings and learn from the greatest legal minds of their time. This system of legal education created practitioners who understood law not as an abstract intellectual exercise, but as a living social institution that had to serve the practical needs of real communities. The emphasis was always on wisdom and judgment, rather than just technical knowledge. The Vikings had also developed what we might call continuing legal education requirements. Even experienced legal practitioners were expected to continue learning and updating their knowledge throughout their careers. This wasn't formal requirement. It was a cultural expectation that was enforced through peer pressure and professional reputation. The integration of legal practice with other aspects of Viking culture meant that legal practitioners were also expected to be accomplished in poetry, storytelling, history, and religious knowledge. Law wasn't a separate profession. It was part of a broader cultural expertise that encompassed all aspects of community leadership. The concept of legal research in a society without written law books was incredibly sophisticated. Legal practitioners had to maintain vast mental libraries of precedents, procedures, and principles, all organized in ways that allowed for quick retrieval and cross-referencing during legal proceedings. This mental organization of legal knowledge was facilitated by the use of memory techniques that were also used for preserving other forms of cultural knowledge. Legal principles were embedded in poetic forms, narrative structures, and mnemonic devices that made them easier to remember and transmit. The collaborative nature of legal knowledge in Viking society meant that no single person was expected to know everything. Legal proceedings often involved multiple experts who could contribute different aspects of legal knowledge and reasoning. This created a system of collective legal wisdom that was more robust and comprehensive than any individual expertise. The quality control mechanisms for legal knowledge were also sophisticated. Legal practitioners were constantly testing their knowledge against their peers, and errors or gaps in legal understanding would quickly become apparent during legal proceedings. This created powerful incentives for accuracy and continuous learning. The relationship between legal practice and religious observance in Viking society was so intertwined that it's impossible to understand one without the other. Legal practitioners weren't just applying secular rules. They were serving as intermediaries between the human community and divine forces. This religious dimension of legal practice created additional layers of responsibility and accountability. Legal practitioners weren't just answerable to their clients and their communities. They were answerable to the gods whose will they were attempting to discern and implement. The ritual aspects of legal proceedings weren't just ceremonial window dressing. They were essential elements that connected legal decisions to the cosmic order. Every legal proceeding was simultaneously a practical problem-solving exercise and a religious ceremony designed to ensure that human justice aligned with divine will. The Vikings had developed elaborate procedures for purifying legal spaces, consecrating legal instruments, and invoking divine guidance for legal decisions. These rituals weren't separate from the legal reasoning process. They were integrated elements that were believed to improve the quality of legal decision-making. The concept of legal pollution that we discussed earlier extended to the legal practitioners themselves. Judges and advocates who made decisions that were later determined to be unjust could face not just professional consequences, but spiritual contamination that required elaborate cleansing rituals. This created incredibly powerful incentives for legal practitioners to take their responsibilities seriously and to approach their work with appropriate humility and reverence. The stakes weren't just professional reputation, they were spiritual purity and cosmic harmony. The training of legal practitioners included not just technical legal knowledge, but also spiritual preparation and purification practices. Legal practitioners were expected to maintain certain standards of personal conduct and spiritual cleanliness that would allow them to serve effectively as conduits for divine justice. The Vikings had developed detailed rules about the personal qualifications required for different types of legal practice. Some roles required specific spiritual preparations, others required particular types of life experience, and still others required demonstrated mastery of specific bodies of legal knowledge. These qualification requirements weren't just arbitrary barriers to entry. They were carefully designed systems for ensuring that legal practitioners had the knowledge, wisdom, and spiritual preparation necessary to handle the responsibilities of their roles effectively. The concept of legal malpractice in Viking society was highly developed and included not just technical errors, but also spiritual failings and violations of professional ethics. Legal practitioners who failed to meet their obligations could face consequences ranging from professional censure to complete exclusion from legal practice. But the Vikings also understood that legal practice was inherently difficult and that even the best practitioners would sometimes make mistakes. They had developed systems for distinguishing between honest errors and negligent or malicious conduct, and they had created mechanisms for remedying mistakes without destroying careers. The rehabilitation of legal practitioners who had made serious errors was also carefully regulated. There were specific procedures for acknowledging mistakes, making appropriate restitution, and demonstrating that the practitioner had learned from their errors and was ready to resume effective practice. The Vikings had even developed what we might call legal insurance systems, where communities would collectively support legal practitioners who face financial ruin as a result of professional mistakes. This wasn't just charity. It was recognition that effective legal practice required practitioners to take risks, and that the community benefited from having practitioners who were willing to tackle difficult cases. The international aspects of Viking legal practice created additional layers of complexity that required specialized knowledge and skills. Legal practitioners who worked on cases involving multiple jurisdictions had to master not just their own legal traditions, but also the legal systems of other communities. This international legal practice led to the development of what we might call comparative legal analysis, where practitioners would systematically compare different legal approaches to similar problems and develop hybrid solutions that drew on multiple legal traditions. The Vikings had developed sophisticated protocols for legal cooperation between different communities, including procedures for sharing evidence, coordinating investigations, and enforcing judgments across territorial boundaries. These weren't formal treaties. They were practical working relationships between legal practitioners who recognized their mutual interdependence. The concept of legal diplomacy was highly developed among Viking legal practitioners. They understood that legal disputes between communities could easily escalate into broader conflicts, and they had developed specialized skills for managing legal cases in ways that promoted peace and cooperation rather than conflict and division. The role of legal practitioners as community leaders extended far beyond formal legal proceedings. They were expected to serve as advisors, mediators, and wise counselors who could help prevent disputes from arising and resolve conflicts before they required formal legal intervention. This broader community leadership role meant that legal practitioners had to maintain not just technical competence, but also moral authority and social credibility. They had to be people that the community could trust with their most important and sensitive problems. The Vikings had developed sophisticated methods for evaluating and maintaining the moral authority of legal practitioners. These included not just formal disciplinary procedures, but also ongoing community assessment of practitioners' character, judgment, and effectiveness. The relationship between legal practice and other forms of community leadership was complex and sometimes competitive. Legal practitioners had to work effectively with political leaders, religious authorities, and economic elites while maintaining their independence and integrity as servants of justice. The Vikings understood that legal systems could only function effectively if they maintained public confidence and legitimacy. This required legal practitioners to be not just technically competent, but also visibly committed to the principles of fairness, honesty, and service to the community good. The mechanisms for maintaining public confidence in the legal system included not just formal accountability procedures, but also ongoing public education about legal principles and procedures. Legal practitioners were expected to be teachers and explainers who could help the community understand how and why the legal system worked. The Vikings had developed sophisticated methods for handling legal cases that attracted significant public attention or controversy. They understood that high-profile cases could either strengthen or undermine public confidence in the legal system, and they had created procedures designed to ensure that these cases were handled with particular care and transparency. The concept of legal precedent that we discussed earlier was particularly important in high-profile cases, because these cases were most likely to be remembered and cited in future legal proceedings. Legal practitioners working on these cases had to consider not just the immediate resolution of the dispute, but also the long-term implications for legal development. The Vikings had also developed procedures for handling legal cases that involved powerful or influential people, who might be tempted to use their position to influence legal outcomes. These procedures were designed to ensure that justice was blind to social status, while still recognizing the practical realities of power relationships in small communities. The balance between equality before the law and recognition of social hierarchy was one of the most delicate aspects of Viking legal practice. Legal practitioners had to navigate these tensions carefully to maintain both the integrity of the legal system and their own effectiveness as community leaders. The concept of legal courage was highly valued in Viking society. Legal practitioners were expected to be willing to make unpopular decisions and stand up to powerful interests when justice required it. This wasn't just professional obligation, it was a fundamental character requirement for anyone who wanted to serve as a legal practitioner. But the Vikings also understood that legal courage without wisdom could be destructive rather than helpful. They had developed sophisticated methods for distinguishing between principled stands and stubborn foolishness. And they had created support systems for practitioners who found themselves in difficult positions because of their commitment to justice. The training of legal practitioners included not just technical and spiritual preparation, but also character development, designed to produce people who had the moral strength to handle the difficult responsibilities of legal practice. This character training was considered just as important as technical knowledge. The Vikings had developed detailed theories about the personal qualities that made for effective legal practice, and they had created educational systems designed to identify and develop these qualities in potential practitioners. This wasn't just professional training, it was comprehensive human development. The concept of legal legacy was important to Viking legal practitioners. They understood that their decisions and actions would be remembered and would influence future generations of practitioners and community members. This created additional incentives for excellence and integrity in legal practice. The ways that Viking legal practitioners were remembered and honored reveal a lot about what their society valued in legal practice. The greatest practitioners were remembered not just for their technical skills, but for their wisdom, their integrity, and their service to the community good. The stories told about legendary legal practitioners became part of the educational tradition that shaped future generations of practitioners. These stories weren't just entertainment, they were moral and professional instruction that transmitted the values and standards of the legal profession. The Vikings had developed sophisticated methods for preserving and transmitting the memory of great legal practitioners and their most important cases. This wasn't just hero worship, It was systematic preservation of legal wisdom and professional examples that could guide future practice. The preservation of legal wisdom through storytelling wasn't just about remembering famous cases. It was about creating a living library of legal knowledge that could adapt and evolve with changing circumstances. When a young legal practitioner heard the story of how a legendary advocate handled a complex property dispute 3 generations earlier, they weren't just learning about that specific case, they were absorbing the underlying principles, the reasoning process, and the ethical framework that guided the decision. This storytelling tradition created something remarkable: a legal system that could maintain consistency across centuries without becoming rigid or outdated. The stories carried the essential DNA of Viking justice, while allowing each generation to interpret and apply those principles to new situations and challenges. But here's where it gets absolutely fascinating. The Vikings had figured out something that modern legal systems still struggle with: how to balance individual rights with community needs. They understood that pure individualism could destroy social cohesion, but they also recognized that excessive community control could crush individual initiative and creativity. Their solution was something we might call graduated individualism. Your personal autonomy and legal rights expanded as you demonstrated your commitment to the community and your ability to handle responsibility. Young people had fewer rights, but also fewer obligations. As you matured and proved yourself, you gained more freedom, but also more responsibility for the welfare of others. This wasn't arbitrary age discrimination. It was a sophisticated system that recognized that rights and responsibilities needed to develop together. Someone who had never demonstrated the ability to manage their own affairs responsibly couldn't be expected to make decisions that affected the entire community. The Vikings had developed detailed procedures for evaluating when someone was ready to take on additional rights and responsibilities. These weren't just formal ceremonies. They were comprehensive assessments that looked at practical skills, moral character, and social judgment. The concept of legal maturity in Viking society was far more nuanced than our modern systems of legal age. They understood that people developed at different rates, and that chronological age was just one factor in determining someone's readiness for various types of legal responsibility. Some people might be considered mature enough to own property and enter into contracts while still being considered too young for certain types of legal advocacy or community leadership. Others might demonstrate exceptional wisdom at a young age and be granted responsibilities that were normally reserved for older community members. This flexibility in determining legal capacity created a system that could make better use of individual talents while still protecting people who weren't ready for certain responsibilities. It was individualized justice that took into account the specific circumstances and capabilities of each person. The Vikings had also developed sophisticated methods for handling people whose legal capacity changed over time due to injury, illness, or other circumstances. They understood that legal capacity wasn't permanent, and that people might need different types of support and protection at different stages of their lives. The concept of temporary incapacity was well developed and included not just obvious cases like serious illness, but also situations where someone might be temporarily unable to handle their affairs due to grief, emotional trauma, or other life circumstances. These temporary incapacity provisions weren't just practical accommodations. They were recognition that life is unpredictable and that legal systems need to be flexible enough to help people through difficult periods without permanently damaging their legal standing. The Vikings had developed elaborate support systems for people who were temporarily unable to manage their own affairs. These weren't just informal family arrangements. They were legal structures with specific rights, obligations, and oversight mechanisms. The restoration of full legal capacity after a period of incapacity was also carefully regulated. There were specific procedures for evaluating when someone was ready to resume full responsibility for their affairs, and there were safeguards to prevent premature or inappropriate restoration of capacity. But perhaps the most remarkable aspect of Viking legal thinking was their understanding of collective decision-making. They had figured out how to harness the wisdom of groups while avoiding the dangers of mob rule. Their legal assemblies weren't just democratic free-for-alls where everyone shouted their opinions. They were structured, deliberative processes designed to produce thoughtful, well-reasoned decisions. The procedures for conducting legal assemblies were incredibly sophisticated. There were specific rules about who could speak when, how long they could speak, what types of evidence could be presented, and how decisions would be made. These rules weren't arbitrary restrictions. They were carefully designed systems for ensuring that all relevant perspectives were heard while maintaining order and focus. The role of the assembly moderator was crucial and required special skills and training. These weren't just people who called for quiet when things got too noisy. They were skilled facilitators who could guide complex discussions, manage conflicting personalities, and help groups reach sound decisions even when dealing with emotionally charged issues. The Vikings had developed sophisticated methods for structuring group discussions to maximize the quality of decision-making. They understood that the order in which people spoke, the way questions were framed, and the physical arrangement of the assembly could all influence the outcome of deliberations. The concept of deliberative democracy that the Vikings practiced was far more advanced than most modern democratic processes. They had figured out how to combine genuine participation with expert knowledge, emotional expression with rational analysis, and individual perspectives with collective wisdom. The Vikings had also developed methods for handling situations where legal assemblies couldn't reach clear decisions or where the community was deeply divided on important issues. They had procedures for managing deadlocks, facilitating compromise, and finding creative solutions that could satisfy competing interests. These conflict resolution procedures weren't just mechanical voting systems. They were sophisticated processes that involved multiple rounds of discussion, structured negotiations between opposing factions, and creative problem-solving techniques that could identify solutions that nobody had initially considered. The Vikings understood that some legal decisions were too important to be made by simple majority vote. They had developed procedures for building genuine consensus on crucial issues, even when that process took much longer than simple voting would have required. The concept of qualified consensus was particularly sophisticated. The Vikings understood that not all opinions were equally valuable, and that some decisions required the agreement of people with specific expertise or stake in the outcome. They had developed methods for identifying whose agreement was essential for different types of decisions. But they also understood the dangers of giving too much power to experts or special interests. They had created checks and balances that ensured that specialized knowledge was taken into account without allowing any group to dominate the decision-making process. The integration of expert knowledge with democratic participation was one of the most impressive aspects of Viking legal assemblies. They had figured out how to tap into specialized expertise while still maintaining genuine community control over important decisions. The Vikings had developed sophisticated methods for educating assembly participants about complex issues so that democratic deliberation could be truly informed. These weren't just information dumps. They were structured educational processes that helped ordinary community members understand the implications of different policy choices. The concept of civic education in Viking society was far more advanced than most modern democracies. They understood that effective democratic participation required ongoing education and preparation, not just the right to show up and vote. The Vikings had created systems for developing civic skills and knowledge that began in childhood and continued throughout people's lives. This wasn't formal schooling. It was integrated into all aspects of community life, so that everyone developed the knowledge and skills needed for effective participation in democratic governance. The role of mentorship in developing civic capacity was particularly important. Experienced community leaders would take responsibility for training younger people in the skills and knowledge needed for effective participation in legal and political processes. These mentorship relationships weren't just informal guidance. They were structured educational partnerships with specific goals, methods, and accountability mechanisms. The Vikings understood that democratic citizenship required specific skills that needed to be deliberately developed and practiced. The concept of civic apprenticeship was well developed and included not just observation of legal proceedings, but active participation in increasingly complex and responsible roles. Young people would gradually take on more significant responsibilities as they demonstrated their competence and commitment. The Vikings had also developed methods for evaluating and improving the quality of their democratic processes. They understood that democratic institutions needed constant attention and refinement to remain effective, and they had created mechanisms for identifying and addressing problems in their decision-making systems. The concept of institutional learning was sophisticated and included not just formal reviews of legal procedures, but ongoing experimentation with new methods and approaches. The Vikings were constantly trying to improve their legal and political systems based on experience and changing circumstances. This experimental approach to institutional design meant that Viking legal systems evolved continuously, rather than becoming frozen in traditional forms. They were conservative in their commitment to core principles, but innovative in their willingness to try new methods for achieving those principles. The Vikings had developed sophisticated methods for testing new legal procedures and institutional arrangements before implementing them broadly. They understood that institutional changes could have unintended consequences, and that careful experimentation was necessary to avoid damaging effective systems. The role of pilot programs and limited trials in institutional innovation was well developed. The Vikings would often test new legal procedures in specific communities or for specific types of cases before deciding whether to adopt them more broadly. The evaluation of these experimental programs was rigorous and included not just formal assessments of outcomes, but also careful attention to unintended effects and long-term implications. The Vikings understood that institutional changes could have complex effects that might not be immediately apparent. The Vikings had also developed sophisticated methods for scaling successful innovations from small communities to larger territories. They understood that legal procedures that worked well in small homogeneous communities might need modification to work effectively in larger, more diverse settings. The concept of adaptive implementation was well developed and included systematic methods for modifying legal procedures based on local conditions and circumstances. The Vikings understood that one size doesn't fit all when it comes to legal institutions, but they also understood the importance of maintaining consistency and compatibility between different legal systems. They had developed methods for ensuring that local adaptations didn't undermine the broader framework of legal principles that held their civilization together. The balance between local autonomy and system-wide coherence was one of the most sophisticated aspects of Viking legal thinking. They had created federal-style systems that allowed for local variation while maintaining overall unity and compatibility. The mechanisms for coordinating between different legal jurisdictions were incredibly advanced. The Vikings had developed systematic methods for sharing information, coordinating investigations, and ensuring that legal decisions in one community didn't create problems for neighboring communities. The concept of legal diplomacy between communities was highly developed and included not just formal agreements, but ongoing working relationships between legal practitioners from different jurisdictions. These relationships were crucial for managing the complex legal issues that arose in a mobile society where people frequently traveled and conducted business across territorial boundaries. The Vikings had developed sophisticated protocols for handling legal cases that involved multiple jurisdictions or that required cooperation between different legal authorities. These protocols weren't just administrative procedures. They were carefully designed systems for ensuring that complex cases were handled fairly and effectively. The concept of legal reciprocity was central to these interjurisdictional relationships. Communities agreed to recognize each other's legal decisions and to provide mutual assistance in legal matters, creating a kind of legal common market that facilitated trade and travel. But these reciprocity agreements weren't just blanket acceptances of foreign legal decisions. The Vikings had developed sophisticated methods for evaluating whether foreign legal procedures met their standards for fairness and legitimacy before agreeing to recognize the results. The standards for recognizing foreign legal decisions were detailed and specific. They included requirements about procedural fairness, evidence standards, and the qualifications of legal decision makers. These weren't arbitrary barriers. They were quality control mechanisms designed to ensure that legal cooperation didn't undermine local standards of justice. The Vikings had also developed procedures for handling situations where they couldn't recognize foreign legal decisions because of procedural problems or substantive disagreements. These procedures were designed to manage disagreements without destroying the broader framework of legal cooperation. The concept of legal conflict resolution between jurisdictions was sophisticated and included not just formal dispute resolution procedures, but also ongoing dialogue and negotiation designed to prevent conflicts from arising in the first place. The Vikings understood that legal systems needed to evolve together to maintain compatibility and effectiveness. They had created mechanisms for coordinating legal development across different communities so that changes in one jurisdiction didn't create problems for others. The role of legal conferences and gatherings in coordinating system-wide development was crucial. Legal practitioners from across the Viking world would gather regularly to share experiences, discuss new developments, and coordinate approaches to emerging legal challenges. These gatherings weren't just social events. They were working conferences where serious legal business was conducted. Legal practitioners would present difficult cases, discuss innovative solutions, and work together to develop new approaches to legal challenges. The Vikings had developed sophisticated methods for documenting and disseminating the results of these legal conferences. Even though they didn't have written legal codes, they had systematic ways of preserving and sharing new legal knowledge and innovations. The concept of legal publication in an oral culture was highly developed and included not just formal presentations, but also structured methods for ensuring that new legal knowledge was accurately transmitted to communities that couldn't send representatives to major gatherings. The Vikings had created networks of legal messengers and traveling practitioners who served as conduits for legal information between communities. These weren't just informal communication channels. They were systematic information networks with specific responsibilities and quality control mechanisms. The accuracy and reliability of legal information transmission was crucial for maintaining system-wide coherence. The Vikings had developed sophisticated methods for verifying legal information and ensuring that new developments were accurately understood and implemented. The concept of legal standardization in an oral culture required innovative approaches that were very different from modern methods of ensuring consistency. The Vikings had developed mnemonic systems, standardized formulations, and verification procedures that could ensure accuracy without written documentation. The role of poetry and song in preserving and transmitting legal knowledge was sophisticated and served multiple functions beyond just memory aid. The artistic elements of legal knowledge made it more engaging and memorable, while also creating aesthetic standards that helped maintain accuracy. The Vikings understood that legal knowledge needed to be not just accurate, but also inspiring and emotionally engaging. They had developed methods for creating legal formulations that were intellectually sound, practically useful, and aesthetically satisfying. The integration of artistic and legal excellence created a cultural environment where legal practice was considered one of the highest forms of human achievement. The greatest legal practitioners were celebrated not just for their technical skills, but for their ability to create beautiful and moving expressions of justice. This aesthetic dimension of legal practice had practical implications beyond just cultural prestige. The Vikings believed that beautiful legal formulations were more likely to be true and just than ugly or awkward ones. They had developed sophisticated theories about the relationship between aesthetic excellence and moral truth. The concept of legal beauty wasn't just superficial decoration. It was understood to be an indicator of deeper harmony and correctness. Legal arguments that were elegantly structured and beautifully expressed were considered more persuasive and more likely to produce just outcomes. The Vikings had developed systematic methods for evaluating the aesthetic quality of legal arguments and decisions. These weren't arbitrary artistic judgments. They were sophisticated analytical frameworks that connected formal beauty with substantive excellence. The training of legal practitioners included not just technical and ethical instruction, but also aesthetic education designed to develop the artistic sensibilities needed for excellent legal practice. This wasn't considered a luxury. It was understood to be essential for the highest levels of legal achievement. The concept of legal craftsmanship was highly developed and included not just the content of legal decisions, but also their form, style, and presentation. The Vikings understood that how legal decisions were expressed was just as important as what those decisions were. The standards for legal craftsmanship were demanding and required practitioners to master not just legal principles, but also the artistic techniques needed to express those principles beautifully and persuasively. This created a legal culture that valued excellence in all dimensions of practice. The Vikings had developed sophisticated methods for teaching and evaluating legal craftsmanship. These included not just formal instruction, but also apprenticeship relationships, peer review processes, and community feedback mechanisms that helped practitioners develop and refine their artistic skills. The concept of legal performance was central to Viking legal practice. Legal proceedings weren't just administrative processes. They were dramatic performances that needed to engage and move audiences while also achieving practical legal goals. The skills required for effective legal performance were complex and demanding. Legal practitioners needed to be skilled actors, storytellers, and public speakers who could command attention, convey complex information, and inspire confidence in their audiences. The Vikings had developed systematic training methods for developing performance skills in legal practitioners. These included not just formal instruction, but also extensive practice opportunities and mentorship relationships with master performers. The evaluation of legal performance was sophisticated and included not just assessment of technical accuracy, but also evaluation of emotional impact, audience engagement, and overall effectiveness in achieving legal goals. The Vikings understood that legal performance needed to be authentic and genuine rather than just technically skillful. They had developed methods for distinguishing between genuine legal excellence and mere theatrical showmanship. The concept of legal authenticity was central to their understanding of effective legal practice. Legal practitioners needed to embody the principles they were advocating, rather than just performing them for effect. This created demanding standards for personal integrity and moral development. The Vikings had developed sophisticated methods for evaluating and developing the personal authenticity of legal practitioners. These included not just formal assessment procedures, but also ongoing community observation and feedback about practitioners' character and conduct. The relationship between personal character and professional effectiveness was understood to be fundamental rather than incidental. The Vikings believed that legal practitioners who lacked genuine moral authority couldn't be truly effective regardless of their technical skills. This emphasis on character development meant that legal education in Viking society was fundamentally different from modern professional training. It wasn't just about acquiring knowledge and skills. It was about becoming the kind of person who could serve effectively as an instrument of justice. The Vikings had developed comprehensive theories about the personal qualities needed for effective legal practice, and systematic methods for developing those qualities in aspiring practitioners. This character development was considered just as important as technical training. The concept of legal vocation was central to Viking understanding of legal practice. Legal practitioners weren't just people who had learned certain skills. They were people who had been called to serve justice and who had undergone the personal transformation necessary to fulfill that calling. This vocational understanding of legal practice created different standards and expectations than purely professional approaches. Legal practitioners were expected to maintain their commitment to justice throughout their lives rather than just during working hours. The Vikings had developed sophisticated support systems for helping legal practitioners maintain their vocational commitment over long careers. These included not just professional development opportunities, but also spiritual and personal support designed to prevent burnout and maintain motivation. The concept of legal service was understood to be demanding and potentially costly for practitioners. The Vikings recognized that serving justice sometimes required personal sacrifice and that practitioners needed community support to sustain their commitment over time. The compensation and recognition systems for legal practitioners were designed to acknowledge both their contributions and their sacrifices. These weren't just economic arrangements, they were comprehensive support systems that addressed practitioners' material, social, and spiritual needs. The Vikings understood that legal systems could only be as good as the people who operated them, and that attracting and retaining excellent practitioners required careful attention to their needs and circumstances. They had developed sophisticated strategies for ensuring that legal practice remained attractive to talented and committed individuals. The concept of legal legacy was important not just for individual practitioners, but for the entire system. The Vikings understood that each generation of legal practitioners was responsible for preserving and improving the legal system for future generations. This intergenerational responsibility created additional layers of accountability and motivation for legal practitioners. They weren't just serving their immediate clients and communities, they were serving the long-term interests of their civilization. The Vikings had developed systematic methods for ensuring continuity and improvement across generations of legal practitioners. These included not just formal training programs, but also mentorship relationships, knowledge preservation systems, and institutional development processes. The concept of legal stewardship was central to Viking understanding of professional responsibility. Legal practitioners were understood to be temporary custodians of a precious inheritance that needed to be preserved and enhanced for future generations. This stewardship responsibility extended beyond just technical legal knowledge to include the moral and spiritual dimensions of legal practice. Each generation was responsible for maintaining and developing the character and wisdom needed for effective service to justice. The Vikings had developed sophisticated methods for evaluating how well each generation was fulfilling its stewardship responsibilities. These evaluations included not just assessment of immediate outcomes, but also long-term analysis of trends and developments in legal practice. The mechanisms for course correction when legal systems were heading in problematic directions were well developed and included both formal procedures and informal cultural processes for identifying and addressing problems. The Vikings understood that legal systems, like all human institutions, were subject to corruption and decay over time. They had developed systematic approaches for maintaining institutional health and preventing the gradual deterioration that could undermine effective legal practice. The concept of institutional renewal was sophisticated and included not just periodic reforms, but ongoing processes of reflection, evaluation, and improvement designed to keep legal systems vibrant and effective. The Vikings had created cultural practices and institutional mechanisms that could generate the energy and commitment needed for continuous legal system improvement. These weren't just administrative procedures, they were comprehensive approaches to institutional vitality. The role of crisis and challenge in institutional renewal was understood and accepted. The Vikings recognized that legal systems sometimes needed to be tested and stressed to reveal weaknesses and generate the motivation needed for improvement. But they also understood that not all challenges were beneficial, and that legal systems needed to be protected from destructive forces that could undermine their effectiveness. They had developed sophisticated methods for distinguishing between constructive and destructive challenges. The Vikings had created resilient legal systems that could survive and learn from crises while maintaining their core integrity and effectiveness. This resilience wasn't just passive durability, it was active adaptability that could turn challenges into opportunities for improvement. The concept of legal evolution was central to Viking institutional thinking. They understood that legal systems needed to change and develop over time to remain effective, but they also recognized that not all change was beneficial. The Vikings had developed sophisticated criteria for evaluating proposed changes to legal systems and procedures. These criteria included not just immediate practical considerations, but also long-term implications for institutional integrity and effectiveness. The mechanisms for implementing beneficial changes while preventing harmful ones were complex and included multiple layers of review, testing, and evaluation. The Vikings understood that institutional change needed to be careful and deliberate rather than hasty or impulsive. The concept of legal wisdom was central to their approach to institutional development. They understood that effective change required not just good intentions, but also deep understanding of how legal systems worked and how changes might affect their operation. The Vikings had developed systematic methods for accumulating and applying legal wisdom across generations. These methods included not just formal knowledge preservation, but also practical apprenticeship systems that could transmit tacit knowledge and judgment. The role of elder legal practitioners in institutional development was crucial and included not just advisory functions, but also active participation in evaluation and improvement processes. The Vikings understood that experience and wisdom were irreplaceable resources for institutional development, but they also understood that elder practitioners needed to work effectively with younger generations to ensure that institutional development remained dynamic and responsive to changing circumstances. They had developed sophisticated methods for managing intergenerational collaboration in legal system development. The concept of legal innovation was valued but carefully managed. The Vikings understood that innovation was necessary for institutional vitality, but that poorly conceived innovations could be destructive rather than beneficial. The methods for evaluating and implementing legal innovations were rigorous and included extensive testing, peer review, and long-term monitoring of results. The Vikings weren't afraid of change, but they were careful about how they managed it. The balance between tradition and innovation was one of the most sophisticated aspects of Viking institutional thinking. They had developed methods for preserving essential traditions while allowing for beneficial innovations and adaptations. This balance required sophisticated judgment and deep understanding of which aspects of legal systems were essential and which could be modified without undermining institutional integrity. The Vikings had developed systematic approaches to making these crucial distinctions. The concept of institutional wisdom was central to their approach to managing change and development. They understood that institutions had their own forms of intelligence that needed to be respected and preserved, even as specific procedures and practices evolved. The Vikings had created legal systems that were simultaneously stable and dynamic, traditional and innovative, conservative and progressive. This wasn't contradiction. It was sophisticated institutional design that could maintain essential functions while adapting to changing circumstances. The mechanisms for achieving this balance were complex and required ongoing attention and adjustment. The Vikings understood that institutional balance wasn't a static condition, but a dynamic process that required constant management and refinement. The concept of legal homeostasis was sophisticated and included not just formal feedback mechanisms, but also cultural processes that could detect and correct institutional imbalances before they became serious problems. The Vikings had developed early warning systems that could identify emerging problems in legal institutions before they became crises. These systems included not just formal monitoring procedures, but also cultural sensitivities that could detect subtle changes in institutional health and effectiveness. The response mechanisms for addressing institutional problems were comprehensive and included both emergency procedures for dealing with crises and long-term development strategies for preventing problems from recurring. The Vikings understood that institutional health required ongoing investment and attention rather than just crisis response. They had developed systematic approaches to institutional maintenance and development that could prevent many problems from arising in the first place. The concept of legal maintenance was far more sophisticated than just fixing problems when they arose. The Vikings had developed comprehensive systems for preventing institutional decay through regular renewal rituals, systematic review processes, and what we might call institutional exercise routines, designed to keep legal systems functioning at peak effectiveness. These maintenance systems weren't just administrative chores. They were elaborate ceremonies that reinforced the spiritual and social foundations of legal authority. Communities would periodically reaffirm their commitment to legal principles through collective rituals that were part religious ceremony, part civic education, and part institutional tune-up. But here's where Viking legal thinking gets absolutely mind-bending. They had figured out how to create legal systems that were essentially self-repairing. Through their sophisticated understanding of social psychology and institutional dynamics, they had built feedback mechanisms that could detect and correct problems automatically, without requiring conscious intervention from legal authorities. Consider how they handled the problem of legal precedent drift. In any legal system that relies on precedent, there's a natural tendency for legal interpretations to gradually shift over time as each generation of practitioners adds their own understanding to inherited traditions. Most legal systems either become rigid to prevent this drift or accept that their legal principles will gradually change beyond recognition. The Vikings solved this through something we might call precedent calibration ceremonies. At regular intervals, communities would gather to recite and discuss the great legal cases of the past, not just as historical curiosities, but as living examples of legal principles in action. These weren't just storytelling sessions. They were systematic reviews designed to ensure that current legal practice remained aligned with traditional principles, while still allowing for appropriate evolution. The genius of this system was that it created automatic correction mechanisms that operated through cultural transmission rather than formal authority. If current legal practice had drifted too far from traditional principles, the contrast would become obvious during these calibration ceremonies, and community pressure would naturally push practice back toward established norms. But if traditional principles needed to evolve to address new circumstances, the calibration process would reveal those needs as well, and the community could consciously decide how to adapt their legal traditions while maintaining essential continuity. The Vikings had also developed what we might call legal immune systems. Just as biological immune systems can distinguish between beneficial and harmful foreign elements, Viking legal systems had sophisticated mechanisms for distinguishing between beneficial innovations and destructive influences. These legal immune systems operated through multiple layers of cultural and institutional filters. New legal ideas or practices would be subjected to systematic evaluation by various groups within the community, each applying different criteria and perspectives. Only innovations that could survive this multi-layered review process would be incorporated into established legal practice. The evaluation criteria weren't arbitrary or purely conservative. The Vikings had developed sophisticated theories about what made legal innovations beneficial or harmful, and they had created systematic methods for applying these theories to specific proposals for change. The concept of legal fitness was central to their evaluation systems. Legal innovations needed to demonstrate that they would enhance rather than undermine the overall health and effectiveness of the legal system. This wasn't just theoretical analysis. It required practical demonstration through limited trials and careful observation of results. But here's what makes this even more remarkable. The Vikings had developed methods for handling legal innovations that were beneficial in some circumstances, but harmful in others. Rather than accepting or rejecting innovations wholesale, they had created sophisticated systems for contextual application that could maximize benefits while minimizing risks. This contextual approach to legal innovation required incredibly sophisticated judgment and deep understanding of how different legal procedures interacted with various social, economic, and cultural factors. The Vikings had developed systematic methods for building and applying this contextual knowledge. The role of legal experimentation in Viking society was carefully regulated but actively encouraged. They understood that legal systems needed to evolve to remain effective, but they also recognized that poorly designed experiments could cause serious harm to individuals and communities. The protocols for legal experimentation were rigorous and included not just formal approval processes, but also ongoing monitoring and evaluation systems designed to identify problems early and prevent serious harm. These weren't just safety measures. They were quality control systems designed to ensure that experiments would produce useful knowledge regardless of their immediate outcomes. The Vikings had developed sophisticated methods for extracting maximum learning from legal experiments, even when those experiments didn't produce the hoped-for results. They understood that failed experiments could be just as valuable as successful ones if the failure was properly analyzed and understood. The concept of legal research in Viking society was far more advanced than you might expect from a culture without written records. They had developed systematic methods for investigating legal questions, testing hypotheses about legal effectiveness, and accumulating knowledge about what worked and what didn't in various circumstances. This legal research wasn't conducted by isolated scholars working in libraries. It was integrated into the daily practice of legal proceedings, with every case serving as a potential source of new knowledge about legal principles and procedures. The Vikings had developed sophisticated methods for ensuring that insights gained from individual legal cases were preserved and shared with the broader legal community. This wasn't just informal gossip. It was systematic knowledge management that could turn individual experiences into collective wisdom. The concept of legal databases in an oral culture required innovative approaches that were very different from modern information systems. The Vikings had developed elaborate mental filing systems that allowed legal practitioners to store, organize, and retrieve vast amounts of legal knowledge without any written records. These mental databases weren't just individual memory systems. They were collective knowledge networks that allowed multiple practitioners to share and verify legal information. The Vikings had developed sophisticated protocols for ensuring the accuracy and reliability of orally transmitted legal knowledge. The quality control mechanisms for legal knowledge were incredibly rigorous and included multiple layers of verification, cross-checking, and peer review. The Vikings understood that inaccurate legal knowledge could cause serious harm, and they had developed systematic approaches to preventing and correcting errors. But perhaps the most impressive aspect of Viking legal knowledge management was their ability to handle uncertainty and ambiguity. They had developed sophisticated methods for distinguishing between established legal principles and tentative hypotheses, between reliable precedents and questionable examples. The Vikings understood that legal knowledge existed on a spectrum of certainty, and they had developed nuanced ways of expressing and applying different levels of confidence in various legal propositions. This wasn't just intellectual sophistication, it was practical wisdom that could prevent overconfident application of uncertain legal principles. The concept of legal epistemology in Viking society was remarkably advanced. They had developed sophisticated theories about how legal knowledge was acquired, validated, and applied. And they had created systematic methods for improving the quality of legal reasoning and decision-making. These epistemological theories weren't just abstract philosophy. They were practical frameworks that guided daily legal practice and helped practitioners make better decisions in complex and uncertain situations. The Vikings had developed systematic approaches to legal reasoning that could handle multiple competing values, conflicting evidence, and uncertain outcomes. These weren't just logical formulas, they were comprehensive frameworks for practical wisdom that could guide decision-making in the most challenging circumstances. The concept of legal judgment in Viking society was understood to be more than just logical analysis or rule application. It was understood to be a complex form of practical wisdom that integrated rational analysis, emotional intelligence, moral insight, and spiritual discernment. The development of legal judgment was considered one of the highest forms of human development, requiring not just intellectual training, but also moral cultivation and spiritual preparation. The Vikings had developed comprehensive educational systems designed to develop all aspects of legal judgment. The evaluation of legal judgment was sophisticated and included not just assessment of immediate outcomes, but also long-term analysis of patterns and trends in decision-making. The Vikings understood that good legal judgment needed to be demonstrated consistently over time rather than just in isolated cases. The concept of legal wisdom was distinguished from mere legal knowledge or technical skill. Legal wisdom required deep understanding of human nature, social dynamics, and the complex relationships between individual actions and collective consequences. The Vikings had developed systematic methods for cultivating legal wisdom that went far beyond formal education or professional training. These methods included contemplative practices, moral exercises, and experiential learning opportunities designed to develop the deepest levels of practical wisdom. The role of mentorship in developing legal wisdom was particularly important. The Vikings understood that wisdom couldn't just be transmitted through formal instruction. It required personal relationships with wise practitioners who could model excellent judgment and provide guidance through complex moral and practical challenges. These mentorship relationships weren't just professional training arrangements, they were comprehensive developmental partnerships that addressed all aspects of human formation needed for excellent legal practice. The Vikings had developed sophisticated theories about the stages of development in legal wisdom and the different types of training and experience needed at each stage. This wasn't just career planning, it was comprehensive human development theory applied to legal practice. The concept of legal maturity was understood to be a lifelong process rather than something that could be achieved once and maintained automatically. The Vikings had developed systematic approaches to continued growth and development throughout legal careers. The challenges and opportunities for continued development changed as practitioners gained experience and took on different roles within the legal system. The Vikings had developed specialized development programs for practitioners at different career stages. The concept of legal leadership was distinguished from mere technical expertise or professional success. Legal leadership required the ability to inspire others, guide institutional development, and serve the long-term interests of justice, rather than just immediate practical needs. The development of legal leadership capabilities was systematic and included not just formal training, but also carefully structured experience opportunities and mentorship relationships with established leaders. The Vikings had developed sophisticated methods for identifying potential legal leaders and providing them with the experiences and support needed to develop their leadership capabilities effectively. The concept of legal legacy was central to their understanding of leadership development. Legal leaders weren't just serving current needs, they were responsible for developing the next generation of leaders and ensuring the long-term health of legal institutions. This intergenerational responsibility created additional layers of accountability and motivation for legal leaders. They understood that their ultimate success would be measured not just by their immediate achievements, but by the quality of the leaders they developed and the institutions they left behind. The Vikings had developed systematic methods for evaluating the long-term impact of legal leadership, and for ensuring that leadership development remained focused on institutional health rather than just individual success. The concept of institutional legacy was even more sophisticated than individual legacy. The Vikings understood that legal institutions needed to be designed and managed to outlast any individual leader or generation of practitioners. This institutional perspective required thinking about legal system development in terms of centuries rather than years, and it created different priorities and strategies than short-term approaches to legal administration. The Vikings had developed systematic methods for institutional planning and development that could span multiple generations while remaining flexible enough to adapt to changing circumstances. The concept of legal architecture was sophisticated and included not just formal procedures and rules, but also the cultural, social, and spiritual foundations that supported legal institutions. The Vikings understood that legal systems were like complex ecosystems that required careful balance between multiple elements to function effectively. They had developed systematic approaches to legal system design that took into account all of these different elements and their interactions. The maintenance of legal ecosystems required ongoing attention and adjustment, just like biological ecosystems. The Vikings had developed sophisticated monitoring systems that could detect imbalances before they became serious problems. The concept of legal ecology extended beyond individual communities to include the relationships between different legal systems and the broader cultural and political environment in which they operated. The Vikings had developed systematic approaches to managing these broader ecological relationships that could maintain local autonomy while ensuring compatibility and cooperation with neighbouring legal systems. The concept of legal sustainability was central to their approach to institutional design and management. They understood that legal systems needed to be designed to function effectively over long periods without exhausting their human, cultural, or spiritual resources. This sustainability perspective required different approaches to legal system management than short-term efficiency or effectiveness measures would suggest. The Vikings had developed sophisticated methods for balancing immediate needs with long-term sustainability requirements. The concept of legal regeneration was also important. The Vikings understood that legal systems needed to be able to renew themselves periodically to maintain their vitality and effectiveness over time. These regeneration processes weren't just administrative reforms. They were comprehensive renewal ceremonies that could reinvigorate the spiritual and cultural foundations of legal authority. The Vikings had developed systematic approaches to legal regeneration that could revitalize legal systems without destroying their essential continuity and stability. The timing and management of regeneration processes was crucial and required sophisticated judgment about when renewal was needed and how it could be accomplished effectively. The Vikings had developed sophisticated methods for managing the transition periods during legal regeneration, ensuring that essential legal functions continued while institutional renewal was taking place. The concept of legal transformation was distinguished from mere reform or adjustment. Transformation involved fundamental changes in the nature and operation of legal systems, and it required very different approaches than incremental improvement. The Vikings had developed systematic methods for managing legal transformation when it was necessary, but they also had sophisticated criteria for determining when transformation was actually needed rather than just desired. The risks associated with a legal transformation were well understood, and the Vikings had developed comprehensive risk management strategies that could minimize the dangers while maximizing the benefits of fundamental change. The concept of legal revolution was also recognized and understood. The Vikings knew that sometimes legal systems became so dysfunctional that they needed to be completely replaced rather than reformed or transformed. But they also understood the enormous risks associated with legal revolution and had developed sophisticated methods for avoiding the need for revolutionary change through effective maintenance, reform, and transformation processes. The Vikings had created legal systems that were remarkably resilient and adaptable, capable of surviving and learning from enormous challenges while maintaining their essential integrity and effectiveness. This resilience wasn't just passive durability, it was active adaptability that could turn challenges into opportunities for growth and improvement. The concept of legal anti-fragility was implicit in Viking institutional design. Their legal systems weren't just designed to survive stress, they were designed to become stronger and more effective when subjected to appropriate challenges. This anti-fragile quality required sophisticated understanding of the difference between beneficial and harmful stress, and the Vikings had developed systematic methods for managing exposure to challenges in ways that promoted growth rather than damage. The concept of legal immunity was also sophisticated. The Vikings understood that legal systems needed to be protected from certain types of harmful influences while remaining open to beneficial innovations and adaptations. The development of legal immunity required careful balance between protection and openness, and the Vikings had developed sophisticated methods for maintaining this balance effectively. The concept of legal symbiosis was central to their understanding of how legal systems related to other social institutions. The Vikings understood that legal systems couldn't function in isolation, but needed to maintain healthy relationships with religious, economic, and political institutions. These symbiotic relationships required ongoing management and adjustment to ensure that they remained mutually beneficial rather than parasitic or destructive. The Vikings had developed sophisticated methods for managing institutional relationships that could maximize the benefits of cooperation while minimizing the risks of institutional capture or corruption. The concept of legal independence was balanced with recognition of necessary interdependence. The Vikings understood that legal systems needed to maintain their integrity and autonomy while still functioning effectively within broader social and political contexts. This balance between independence and interdependence required sophisticated institutional design and ongoing management to maintain effectively. The Vikings had developed systematic approaches to institutional boundary management that could protect legal autonomy while enabling necessary cooperation and coordination with other institutions. The concept of legal sovereignty was sophisticated and included not just formal authority, but also practical capability and moral legitimacy. The Vikings understood that effective legal sovereignty required all three elements working together. The development and maintenance of legal sovereignty was systematic and included ongoing attention to formal structures, practical capabilities, and moral foundations. The Vikings had developed sophisticated methods for defending legal sovereignty against various types of threats, while maintaining the flexibility and openness needed for effective legal system operation. The concept of legal diplomacy was highly developed and included not just formal negotiations between legal authorities, but also ongoing relationship management designed to prevent conflicts and promote cooperation. These diplomatic capabilities were essential for managing the complex relationships between different legal jurisdictions and for maintaining the broader framework of legal cooperation that made Viking civilization possible. The Vikings had developed systematic training programs for legal diplomats and sophisticated protocols for managing diplomatic relationships between legal systems. The concept of legal alliance was also important. The Vikings understood that individual legal systems could be stronger and more effective when they worked together with compatible systems. These alliances weren't just formal agreements, they were ongoing relationships that required constant attention and management to maintain effectively. The Vikings had developed sophisticated methods for building and maintaining legal alliances that could provide mutual support and cooperation while respecting the autonomy and integrity of individual legal systems. The concept of legal confederation was the most advanced form of inter-system cooperation that the Vikings developed. These confederations could coordinate legal policies and procedures across large territories while maintaining local autonomy and flexibility. The management of legal confederations required sophisticated institutional design and ongoing diplomatic management to balance the competing demands of unity and diversity. The Vikings had created confederate legal systems that were remarkably stable and effective, capable of managing complex legal challenges across vast territories and diverse populations. These confederate systems weren't just administrative arrangements, they were comprehensive frameworks for legal cooperation that included cultural, spiritual, and practical dimensions. The success of Viking legal confederations demonstrated the possibility of creating large-scale legal systems that could maintain both effectiveness and legitimacy across diverse communities and territories. But perhaps the most remarkable achievement of Viking legal thinking was their understanding of how legal systems related to the deepest questions of human existence and cosmic order. They didn't see law as just a practical tool for managing social problems. They saw it as a fundamental aspect of the relationship between human communities and the divine forces that govern the universe. This cosmic perspective on legal practice created additional layers of meaning and responsibility that elevated legal work beyond mere technical problem solving to participation in the ongoing creation and maintenance of cosmic harmony. The Vikings understood that legal decisions had implications that extended far beyond their immediate practical effects. Every legal proceeding was simultaneously a practical dispute resolution and a cosmic drama that could affect the fundamental relationships between human communities and divine forces. This cosmic dimension of legal practice required legal practitioners to maintain not just technical competence, but also spiritual purity and moral authority that could serve as effective channels for divine justice. The Vikings had developed sophisticated methods for maintaining the spiritual dimensions of legal practice while still addressing practical legal needs effectively. The integration of practical and cosmic dimensions in legal practice created a form of jurisprudence that was simultaneously grounded in practical reality and oriented toward transcendent truth and justice. This integration wasn't just theoretical, it was practical wisdom that could improve the quality of legal decision-making by connecting immediate choices to broader patterns of meaning and value. The Vikings had created legal systems that could serve both practical and spiritual needs effectively, creating frameworks for justice that were both functional and meaningful. The legacy of Viking legal thinking extends far beyond the historical period in which it flourished. The principles and methods they developed continue to offer insights and inspiration for contemporary legal systems struggling with similar challenges. The Viking understanding of how to balance individual rights with community needs, how to maintain institutional integrity while allowing for necessary change, and how to integrate practical problem solving with deeper questions of meaning and value remains relevant and valuable today. Their sophisticated approaches to democratic participation, institutional design, and legal education offer models and inspiration that could inform contemporary efforts to improve legal systems and democratic institutions. The Viking achievement in creating legal systems that were simultaneously stable and dynamic, traditional and innovative, practical and meaningful, demonstrates that these apparent contradictions can be resolved through sophisticated institutional design and cultural wisdom. Their success in maintaining effective legal systems across vast territories and diverse populations without centralized authority offers valuable insights for contemporary challenges in legal globalization and international cooperation. But perhaps most importantly, the Viking example demonstrates that legal systems can be both practically effective and spiritually meaningful, serving not just immediate social needs, but also deeper human aspirations for justice, harmony, and transcendent meaning. The weird world of Viking justice wasn't just weird, it was wonderfully sophisticated, remarkably effective, and profoundly meaningful in ways that continue to challenge and inspire our understanding of what legal systems can be and do. The enduring fascination with Viking justice lies not just in its strangeness, but in its startling sophistication. When we strip away the Hollywood stereotypes and dig into the archaeological evidence, what emerges is a legal framework that was centuries ahead of its time in some respects, while being utterly alien to our modern sensibilities in others. Think about what the Vikings accomplished without any of the tools we consider essential for complex legal systems. No law schools, no bar associations, no written statutes, no police force, no prisons, no appellate courts. Yet they created a system of justice that maintained order across an empire that stretched from Greenland to Constantinople, that lasted for centuries, and that influenced legal development across Europe. The key to understanding this achievement lies in recognizing that Viking law wasn't just a set of rules and procedures. It was a complete world view that integrated practical problem solving with spiritual beliefs, individual rights with community obligations, and local autonomy with system-wide coherence. Every legal proceeding was simultaneously a practical dispute resolution, a religious ceremony, a community event, and a cosmic drama. This holistic approach to justice created legal systems that could address not just the immediate facts of specific disputes, but the deeper social, emotional, and spiritual needs that legal conflicts reveal. When someone was wronged in Viking society, the legal system didn't just determine guilt and assign punishment. It created opportunities for healing, reconciliation, and the restoration of social harmony. The therapeutic dimensions of Viking justice are particularly striking when compared to modern legal systems that often leave all parties feeling bruised and unsatisfied, even when justice has technically been served. The Vikings understood that legal proceedings needed to address the emotional and social damage caused by conflict, not just the technical legal issues. Consider how they handled something as basic as theft. In our system, a thief might be fined or imprisoned, the stolen goods might be returned, and that's the end of it. But Viking justice recognized that theft created wounds that went far deeper than the mere loss of property. It damaged trust, disrupted community relationships, and created ongoing tensions that could escalate into serious conflicts if not properly addressed. So Viking legal proceedings for theft would include not just restitution and punishment, but elaborate rituals of acknowledgement, apology, and reconciliation, designed to heal the social fabric that had been torn by the crime. The entire community would participate in these proceedings, not just as passive observers, but as active participants in the healing process. The economic sophistication of Viking legal thinking is equally impressive. They had developed complex systems for managing shared resources, resolving commercial disputes, and handling the intricate financial relationships that arose in a society where people regularly traveled vast distances for trade and adventure. Their understanding of risk management was particularly advanced. The Vikings lived in a world where a single trading voyage might involve investments from dozens of people, risks from weather, pirates, and political instability, and potential returns that could make or break entire communities. They had developed legal frameworks that could allocate these risks fairly, protect investors from catastrophic losses, and ensure that successful ventures benefited everyone who had contributed to them. The concept of insurance in Viking society was sophisticated and included not just formal risk-sharing arrangements, but also complex social safety nets that could support individuals and families through disasters and setbacks. These weren't just economic arrangements, they were moral obligations that bound communities together and ensured that temporary misfortune didn't lead to permanent social exclusion. Viking bankruptcy law was centuries ahead of its time in recognizing that debt problems often resulted from circumstances beyond individual control rather than moral failings. They had developed procedures that could protect debtors from complete ruin, while still ensuring that creditors received fair treatment and that the broader economic system maintained stability and confidence. The environmental dimensions of Viking law reveal a sophisticated understanding of humanity's relationship with the natural world. They had developed detailed regulations governing hunting, fishing, logging, and mineral extraction that were designed to ensure sustainable use of natural resources across generations. These environmental regulations weren't just practical resource management. They were expressions of deeper spiritual beliefs about the proper relationship between human communities and the natural forces that sustained them. Violations of environmental law were considered not just practical problems, but spiritual offenses that could bring divine retribution on entire communities. The Vikings had developed elaborate ceremonies for seeking permission from spiritual forces before major resource extraction activities, and they had created detailed protocols for making appropriate offerings and maintaining proper relationships with the natural world. Their understanding of what we might call environmental justice was particularly advanced. They recognized that environmental damage often affected different members of the community unequally, and they had developed legal mechanisms for ensuring that the costs and benefits of resource use were distributed fairly. The international dimensions of Viking law become even more impressive when you consider the challenges they faced in managing legal relationships across vast distances in an age before modern communication and transportation. They had created legal frameworks that could handle disputes involving parties from different continents, different legal traditions, and different languages and cultures. Their approaches to conflict of laws, problems were sophisticated and included systematic methods for determining which legal framework should apply in complex international disputes. They had developed principles that balanced respect for local legal traditions with the need for predictable and fair outcomes in international transactions. The Vikings had also figured out how to handle the enforcement of legal judgments across international boundaries. Through their network of trading relationships and diplomatic connections, they could ensure that legal decisions made in one part of the Viking world would be recognized and enforced in distant territories. This international legal cooperation wasn't imposed by any central authority. It emerged organically from the practical needs of a mobile, trading society. The Vikings had created what was essentially an international legal system through voluntary cooperation and mutual recognition of legal standards. The role of women in Viking legal systems deserves special emphasis because it challenges so many assumptions about medieval society. Viking women had legal rights and opportunities that wouldn't become available to women in most other European societies until centuries later. Women could own property independently, initiate legal proceedings, serve as witnesses in important cases, and even represent others in certain types of legal matters. They had specific legal protections against domestic violence, sexual assault, and economic exploitation that were enforced by community pressure and legal sanctions. The legal status of Viking women wasn't just theoretical, it was actively protected and enforced. Communities took seriously their obligations to protect women's legal rights, and men who violated these rights faced serious consequences, including social ostracism, economic penalties, and in extreme cases, outlawry. Viking marriage law was particularly progressive in recognizing women's rights to initiate divorce proceedings, retain control over their property, and receive fair treatment in custody disputes. These weren't just formal legal rights, they were practical protections that were actively enforced by legal institutions. The Vikings had also developed sophisticated approaches to what we might call family law that recognized the complex realities of medieval family structures. They had legal frameworks for managing polygamous relationships, adoption arrangements, and extended family obligations that were far more nuanced than the simple nuclear family models that dominated later European legal thinking. The treatment of children in Viking legal systems reveals a sophisticated understanding of child development and the special protections that young people need. Viking law recognized that children had different capabilities and needs at different stages of development, and they had created age-appropriate legal frameworks that could protect children while still allowing them to participate in community life. The Vikings had developed detailed guardianship systems that could ensure proper care for orphaned children while protecting their inheritance rights and preparing them for adult responsibilities. These guardianship arrangements weren't just informal family arrangements. They were formal legal relationships with specific rights and obligations that were enforced by community oversight. The concept of children's rights in Viking society was remarkably advanced. Children weren't just considered property of their parents. They were recognized as individuals with their own interests and needs that sometimes required protection from parental authority. The Vikings had developed legal mechanisms for protecting children from abuse, neglect, and exploitation, while still maintaining appropriate respect for parental authority and family autonomy. These child protection systems were community-based rather than centralized, but they were systematic and effective. The educational dimensions of Viking law were comprehensive and included not just formal legal training, but also ongoing community education about legal rights, obligations, and procedures. Everyone in Viking society was expected to understand basic legal principles and to be able to participate effectively in legal proceedings when necessary. This legal education wasn't just academic instruction. It was practical training that was integrated into all aspects of community life. Children learned legal principles through participation in family discussions, community meetings, and legal proceedings. Adults continued their legal education throughout their lives through ongoing participation in the legal system. The Vikings had developed sophisticated methods for ensuring that legal knowledge remained accessible to everyone, regardless of their social status or economic position. Legal proceedings were conducted in plain language that ordinary community members could understand, and legal practitioners were expected to be skilled teachers who could explain complex legal concepts clearly. The democratic dimensions of Viking law extended far beyond just participation in legal proceedings. The Vikings had created comprehensive systems of democratic governance that integrated legal, political, and economic decision-making in ways that ensured broad community participation in all aspects of governance. Their understanding of democratic participation was sophisticated and included not just formal voting procedures, but also comprehensive systems for deliberation, debate, and consensus building that could produce thoughtful and well-informed collective decisions. The Vikings had developed methods for managing the tensions between majority rule and minority rights that were remarkably advanced for their time. They understood that pure majority rule could become tyrannical, and they had created institutional safeguards that could protect minority interests while still enabling effective collective decision-making. Their approaches to leadership selection and accountability were also sophisticated. Viking leaders weren't just elected. They were subjected to ongoing evaluation and could be removed from office if they failed to meet community expectations for effective and ethical leadership. The concept of political representation in Viking society was complex and included not just formal delegation of authority, but also ongoing accountability relationships between leaders and the communities they served. Leaders were expected to maintain regular communication with their constituents and to be responsive to community needs and concerns. The Vikings had also developed sophisticated methods for managing political conflicts and preventing them from escalating into violence or social breakdown. They understood that political disagreements were natural and inevitable in democratic societies, and they had created institutional mechanisms for managing these conflicts constructively. The spiritual dimensions of Viking governance were integrated with practical political considerations in ways that created systems of leadership that were both effective and meaningful. Political leaders weren't just administrators. They were spiritual guides who were expected to maintain proper relationships with divine forces and to ensure that political decisions aligned with cosmic principles. This spiritual dimension of political leadership created additional layers of accountability and responsibility that elevated political service beyond mere technical administration to participation in the ongoing maintenance of cosmic harmony. The Vikings had developed comprehensive systems for training and supporting political leaders that addressed not just technical skills, but also moral development and spiritual preparation. Political leadership was understood to be a sacred calling that required appropriate personal qualities and ongoing spiritual discipline. The legacy of Viking legal and political thinking continues to influence contemporary discussions about democracy, justice, and governance. Their sophisticated approaches to balancing individual rights with community needs, managing cultural diversity within unified political systems, and integrating practical problem-solving with deeper questions of meaning and value offer insights that remain relevant today. The Viking achievement in creating effective legal and political systems without centralized authority demonstrates that alternative approaches to governance are possible and can be highly effective under appropriate circumstances. Their success challenges contemporary assumptions about the necessity of large, centralized bureaucratic institutions for managing complex societies. Their integration of legal, political, economic, and spiritual considerations in unified systems of governance offers models for contemporary efforts to create more holistic and meaningful approaches to public administration and democratic participation. But perhaps most importantly, The Viking example demonstrates that legal and political systems can serve not just immediate practical needs, but also deeper human aspirations for justice, meaning, and transcendent purpose. Their weird world of justice wasn't just functional. It was profoundly meaningful in ways that continue to challenge and inspire our understanding of what human societies can achieve. The Vikings created something truly remarkable: legal systems that were simultaneously practical and spiritual, individual-focused and community-oriented, traditional and innovative, local and universal. They proved that these apparent contradictions could be resolved through sophisticated institutional design, cultural wisdom, and genuine commitment to justice as both practical necessity and transcendent ideal. In our modern world, struggling with questions about how to balance individual rights with social responsibilities, how to maintain democratic institutions in complex societies, and how to create legal systems that serve both practical and spiritual needs. The Viking example offers not just historical curiosity, but genuine wisdom and inspiration. Their weird world of justice turns out to be not just weird, but wonderfully sophisticated, remarkably effective, and profoundly meaningful. It challenges us to think more creatively about what legal systems can be and do, and it demonstrates that human societies are capable of achievements that far exceed what we might expect from their apparent limitations and constraints. The Vikings didn't just create functional legal systems. They created works of art that were simultaneously beautiful and practical, meaningful and effective, traditional and innovative. They showed us what's possible when legal thinking is informed by both practical wisdom and transcendent vision, when legal institutions serve both immediate needs and eternal aspirations. That's the real lesson of Viking justice. It's not enough to create legal systems that work. We need to create legal systems that inspire, that elevate, that connect us to something larger than ourselves, while still addressing the practical challenges of living together in complex societies. The Vikings figured out how to do both, and their example continues to light the way for anyone serious about creating truly excellent systems of justice and governance.